Honorable Court of Criminal Appeals is now back in session. Please be seated.
Good afternoon. Let me start by introducing the panel to you today. To my left is Judge Jill Ayers, who lives in Nashville now, formerly from Clarksville. And to my right is Judge Rob Montgomery, all the way down from Kingsport. I'm Bobby Holloway. I'm from Columbia. Each side will have 20 minutes. If you would like, if the appellant would like to reserve some time for rebuttal, please let us know at the first. Anything else? All right, ready to call the first case?
State of Tennessee versus Benjamin Cloe Byrer.
Good afternoon, Your Honors. I'm David Camp, and I represent Mr. Byrer in regards to this matter. With the court's approval, I'd request at this time 5 minutes for rebuttal, if I may, please. This was a case that was tried in Gibson County, Tennessee, which is the next county over, in regards to a second-degree murder charge that Mr. Byrer had been facing. I think the facts of the case and even a little bit of the procedural history would be somewhat helpful to the court in leading into the argument. I am very much aware the only issue we're presenting to the court today is one entirely upon the basis of insufficiency of the evidence, and I know this court and frankly myself has seen that argued multiple times, but I would submit to the court that this is clearly a basis that the court should consider regardless of the history of insufficiency of evidence, and argue to the court that I think it's perfectly appropriate for the court to reverse a conviction because there was insufficient evidence in this case. The facts of this case were the gentleman named James Cloe was found dead on either March 30th or the early morning hours of March 31st of 2012 at his home at 113 Jim Jackson Road in Humboldt in Gibson County, Tennessee. The defendant in this case, Mr. Byrer, was not indicted until January 4th of 2017, which was now some 5 years after the events and circumstances that led to the ultimate prosecution in this case. The trial did not proceed until September 7th, 8th, and 9th of 2022, which was some 10 years after the events that took place in this case regarding the death of Mr. Cloe. The issues before the court that actually are surrounded by the umbrella of insufficiency of the evidence begins first and foremost with the question of motive. In this instance, the state of Tennessee attempted to try to establish some sort of a motive in this argument that some girlfriend that he, being Mr. Byrer, had an on-again, off-again relationship, a lady by the name of Cassie Johnson, and that somehow Mr. Cloe had let her know that Mr. Byrer had apparently been with some other women, and he sent some pictures to her identifying that. But even the testimony during the course of the trial reflected that her statement to Mr. Byrer was that it was quote Bear, and I think Mr. Cloe was known as Bear, and other people had sent her these pictures. That was it. That was literally what the state rested its entire case on, as to what the motive was for the alleged murder they said took place, and that they said Mr. Byrer did it.
But she testified.
She did. And she was cross-examined, and her testimony was challenged by Mr. Taylor. I did not have the trial in this case. Mr. Daniel Taylor, very competent attorney in town, actually defended Mr. Byrer, so I'm here on the appeal part. But she did testify that is correct. And she was questioned about that and brought out as to what her issues were and some of the discrepancies and disparities, or what I call inconsistencies, in her testimony that she provided. But perhaps more importantly is there were a number of other witnesses that also testified, and I'll go down that list very briefly. Yancy Potts, Shane McBride, Amanda Mayfield, and then I think the last that was called, there may have been one other, but of any significance in this case, was a gentleman named Christopher Lynch, none of whom provided motive. As we sit here to this day, there is still simply nothing before this court, nothing before the trial court, nothing before the jury that ever established a motive for Mr. Byrer to have allegedly done what he did. Now, the facts of the case go a little further. In this instance, as apparently Mr. Byrer finds Mr. Cloe, believes him to be intoxicated, which is why he's on the ground. He calls his own father to come over and help him because there's nobody else around at the time. So his father shows up. His father believes that he's intoxicated. His father calls in his wife, which would be Mr. Byer's mother. She's a nurse practitioner. She comes over and makes the determination that he's not alive. And so they start to do some sort of CPR. They call 911. So in other words, the individual accused of committing the crime is the one who actually calls 911, or at least his father does, and he calls his father to get help. So the real question has to raise itself, and again, I understand, but from sufficient evidence, what would be the motive? And even if he had a motive, what would be his reason for calling authorities and or calling his parents to come to the scene of the crime they said that he committed? So under the circumstances, it was sketchy at best and questionable at worst. But no question at all in this case, there was simply nothing to support or to in any way verify that Mr. Byrer was in fact the person who committed the crime that occurred here. So let's go to the physical evidence if we can, which I think the court has to look at. And I realize in cases like this, Judge Ash would have been the trial court in this matter. He's the 13th juror. There was a motion for judgment of acquittal filed. There was a motion for new trial filed. Both were, of course, denied. But basically, they tried, being the state, to introduce what are referred to as DNA evidence during the course of the trial. But the DNA evidence was at best minor contributions or major contributions to what was they claimed to be the murder weapon, which was a computer cord. Allegedly, there was a strangulation, although they couldn't really identify what it is that actually strangled him, being Mr. Cloe. But the point is, they did fingernail clippings of Mr. Cloe. They did a DNA analysis of the computer cord. They checked the collar of his shirt because they believed it might have been a strangulation involved, and they also checked a cell phone. And the best they could come up with as a major contributor to DNA was Mr. Cloe to all of those, at least to the first two, being the computer cord and the fingernail clippings. Mr. Byer's DNA was not found on the collar of the shirt where allegedly the strangulation took place, and was not found on the cell phone in close proximity to the body that was finally located once the first responders appeared. The computer cord, if Your Honor please, and I think the court will find that in volume 5, page 536, Roy Byrer, who is Mr. Byer's father, said that in fact Benjamin Byrer, that's of course who's on trial here, gave the computer cord to Mr. Cloe, so therefore any evidence of DNA that may have been there was actually provided to Mr. Cloe by, in this case, the defendant. The fingernail clippings had minor, at best again, minor contribution to DNA to Mr. Byrer in this case, but again, that could have easily have been explained just by the basis that he was present when the body was found, and he actually tried to revive, did CPR, and tried to take efforts to resuscitate Mr. Byrer unsuccessfully, as I would add, and it was Mr. Benjamin Byrer who in fact did that. Now, where the real crux comes, and I think is of significant importance for the court to consider, and I know the jury was provided all this, but again, the state still has to have some modicum of proof to carry this, is there was a forensic pathologist brought in to talk about cause of death. Because in this case, allegedly, the state's medical examiner testified that it was strangulation, and that's what caused death. And an autopsy was performed at the time of the death, or sometime thereabout in March of 2012. But Mr. Byrer called to testify, an expert forensic pathologist. He had done in excess of 10,000 autopsies. He had actually trained medical examiners to perform autopsies, and he found that the autopsy performed in this case by the doctor called by the state was inadequate, and that his conclusions that he had reached did not simply meet with whatever the findings were that were there. For example, if there had in fact been strangulation, as was testified to by the forensic or the medical examiner for the state, there was no petechiae. And there should have been, without question, petechiae present in the body at the time the strangulation occurred, if he in fact had been strangled.
And he was cross-examined about that.
He was. He was cross-examined.
All that was presented to the jury.
Yes, ma'am. He was cross-examined about it. It was extensive cross-examination involving his findings. I don't know that the cross-examination was the primary source of the challenge by Mr. Byrer. I think it was the actual introduction of Dr. Hunsacker's testimony that actually questioned the findings in this case. So in other words, I would call it not really cross-examination, I would say impeachment by direct examination presented by the defense in this matter, identifying the discrepancies and the errors that were committed in this report. The real question is was the cause of death put into question significantly enough that the jury could not have reached the conclusion that it was second-degree murder when you could not really truly establish a cause of death in the first place? What Dr. Hunsacker's ultimate opinion is that this gentleman's death could have been caused by an injury or a fall even days prior to his death, where he may have injured the bone in the neck, which ultimately then caused bleeding and or slow bleeding, if you would, that ultimately led to similar or same, the same result was he died as a result of that days later. There was no indication of when the cause of death actually occurred or what the injury was that caused the death. We just know when the body was found. Now, in relation to that as well, the heart was enlarged. He had lungs filled with fluid. He had an enlarged liver, and he was obese. And these were all health contributors that, again, Dr. Hunsaker testified about were, in fact, causative parts of the death in this case as it relates to Mr. Cloe. So there was not any clear or concise cause of death identified, and strangulation was at least eliminated as a potential cause. And that was entirely what the state relied upon is that he died as a means of strangulation. The real question that I'm asking the court to consider, in light of an understanding sufficiency of the evidence being the arguments being raised here, is to look at the expert testimony. His report is as Exhibit 10 that was admitted during the course of the trial in this cause. He testified at length, and I think beginning, if you would, on Volume 5, page 462 and forward, as to his findings and to where he believes conclusively that there was not in this case. If there was a death, it was a death that could have either been, and I think he classified it as this, it could have been homicide, it could have been accidental, or it could have been non-determined. There was no clear way of determining that this man died as a result of homicide. And the question you have to ask, again, as 13th jurors, and in looking at this from a sufficiency of evidence, is based upon the facts presented by the state, should this matter have ever survived a motion for judgment of acquittal? Now, I will give you, Dr. Hunsaker did not testify until the defense put on their proof, which was after the motion for judgment of acquittal. But then should it have survived a motion for new trial, where you revisited the issue of what was presented, and can you really conclusively say that the cause of death was homicide, in this case second-degree murder, was an appropriate finding for the jury to reach under the facts and circumstances that the jury was given? This time, I'd still like to reserve my 5 minutes, if I may, if there's no questions of the court.
Thank you, Mr. Cannon. Any questions?
Thank you, Judge.
All right, Mr. General Douglas.
Good afternoon, Your Honors. May it please the court, Davey Douglas on behalf of the state. This court should affirm the judgments of the trial court because the evidence is sufficient to sustain the defendant's conviction for second-degree murder. The defendant is essentially asking this court to reassess the proof and to reweigh the credibility of witnesses and evidence that were presented at trial. And that's not the role of this court when analyzing the sufficiency of the evidence. Instead, this court looks at the evidence through the light most favorable to the state to consider whether any rational trier of fact could find beyond a reasonable doubt all of the essential elements of the offense. And through this lens, the state's proof is more than sufficient to sustain the conviction for first-degree murder or second-degree murder. Turning to the issue of motive, the state wasn't actually required to prove that element, but it did through the testimony of Cassie Brown and Amanda Mayfield. Cassie Brown was in an on and off again romantic relationship with the defendant. She was supposed to meet up with him on the night of the murder. But in a phone call, she told him that she was upset and hurt because the victim and others had sent her photographs of the defendant with other women, and then she wasn't going to meet up with them. The defendant was at Doug Lemons' house during this conversation, and Mr. Lemons said that the defendant appeared upset at the conclusion of the phone call. And then you had Amanda Mayfield, who also testified that the victim and the defendant did not like each other. So based on the proof that the victim potentially ruined the defendant's romantic relationship with Miss Brown and the fact that he didn't like the victim to begin with, the defendant then left Mr. Lemons' house and announced that he was going to the victim's residence. And then while at the residence, he had ample opportunity to kill the victim, as the two of them were the only ones in the house at the time of the victim's death. There was proof showing that the victim had ligature marks on his wrists, which matched a computer cord that was found in the house, and those marks showed that his hands had been bound before his death. And then you had the victim, there were fingernail clippings of the victim that contained the defendant's DNA, a minor profile of the defendant's DNA. Defendant's DNA was also on the power cord itself. And then you had Dr. LeBoy, who testified about the victim's cause of death, and expressly concluded that it was strangulation. And then you had the defendant's expert who testified, and any question about the victim's cause of death was answered by the jury. And it shows that it credited the state's proof as it was entitled to do. And that proof, again, establishes that the victim was strangled and that the defendant had a reason to do it, a motive to do it, and the opportunity to commit the crime. And Judge Ayers, like you asked, all of these witnesses testified. They were subject to cross-examination. The jury was able to assess their credibility, and its verdict shows that it found the state's witnesses credible rather than the defendant's. And we would therefore, unless there are any questions, ask this court to affirm the defendant's conviction for second-degree murder. Thank you, Your Honors.
Thank you, Mr. Douglas. All right, Mr. Camp, rebuttal?
Very, very brief, if Your Honor, please. I think that most of this has already been covered. I do think the briefs have already outlined this. Sufficiency of the evidence is still a legitimate basis upon which to file an appeal, and it doesn't mean that just because the jury came back with that determination doesn't mean you can't look at the other evidence that was presented. No one's asking this court to go behind whatever the proof may have been at the cause of trial or to explore what happened in the jury. What we're asking the court to do is to look at this as a rational trier of fact and make a determination, is there truly enough facts and evidence there that it should have ever gone to the jury in the first place? And that's what this court's role is. It is actually the same role as the trial court when the trial court is asked to do a motion for new trial. The trial court still has to sustain the verdict of the jury as a 13th juror. And in this instance, we would submit that this court should and can look at the proof and evidence in this case and make a determination there isn't sufficient evidence to support a second-degree conviction. There isn't even sufficient evidence to convict of homicide when you can't establish that a homicide occurred. And that's where the problems and the issues are with this case. So we ask the court to look at that and then reverse the conviction under those circumstances. Thank you.
Thank you, Mr. Camp. All right, ready to go. Ready to call the next case, please?